Well, good afternoon, everybody. I'm Larry Solan, and
well, let me introduce you rather more fulsomely, Larry.
there's a wonderful scene of Mark Twain introducing himself as one of the two people that he most respects in this world, but I wasn't going to say that.
Good afternoon, good evening, everyone. My name is Eugene McNamee, and I'm the head of the law school at Ulster University, and we're delighted this evening to have, as part of a law school endeavour together with the Legal Innovation Centre, Professor Larry Solan from Brooklyn Law School in the United States. Larry is, if not unique, certainly the only well-established legal scholar that I know that also is furnished with a PhD in linguistics, which gives him a unique perspective. Also from our point of view as legal academics, he's doubly unique in that he's been a legal practitioner, as is the American fashion often. Not only that, but a judge's clerk in the United States, so he has experience of drafting judgments for the justices over there. And so this kind of combination of elements that go into making up his resume make him ideally suited to give us a presentation on his new fascination, which is the application of corporal linguistics to legal interpretation. Corporal linguistics, as you know, or I hope that you're interested, as I am, in the notion of legal tech, where the kind of application of big data formulaics to interpretation, to figuring out the meaning by virtue of how often it's being used in certain contexts. So there's a real strong cross-application to notions of artificial intelligence and how that might develop in various different forms of legal practice. So Larry is going to speak to us on those general themes tonight, and I'm delighted to welcome him here this evening.
Thank you so much, Eugene. And I'm really thrilled to be here. We have a budding but growing relationship with your university here. We're very proud of it, and I'm just very happy to be part of this. There's been an interest in the United States, led by judges, in seeing how certain techniques of using big data can be applied in questions of legal interpretation. And I'm going to talk about that. And my own, I've written a paper with Tammy Gales. There's a good deal of work in this area going on continental Europe, incidentally, especially in Germany. So if anybody has a broader interest in these issues of big data and legal analysis of various sorts, if you send me a note, I'm more than happy to send you a few articles or at least some references to things and to make it easier for you to learn more about all of this. Tammy Gales, my co-author, is a linguist. She works in the linguistics department at Hofstra University on Long Island in New York, and she is also part of a forensic linguistics program giving master's degrees on issues of language and law. There's a few universities in the world that do this. All of them are in the United Kingdom except for Hofstra. Cardiff University has a program. Aston University in Birmingham has a program. I'll be there tomorrow. And York has a couple of programs, one involving speech recognition and the like. They're the leading place in the world on that. And they also have some new work on more broader linguistic analysis. And the University of Birmingham was really the initial leader in this field. And the professor that was running it retired because he got old enough that he had to retire a number of years ago. He, for a little while, moved to Aston, and now he started yet another program in Brazil. So there are a few pockets in the world that really have educational programs committed to this sort of thing. My perspective on this is a little more cautious. So I'm going to tell you about what developments have been going on, and then to talk about the criteria that need to be met for it to be useful, in my opinion. Because talking about law and technology, there is a tendency when one has technology to get very excited about the technology and then to say, well, what can we do about it? And try to push particular situations into the technology, because it's exciting. This happened, for example, when universities started buying these fMRI machines, these scanning machines, brain scans. And then they realized that they had no questions that they wanted answered. So you'd see signs, we have this machine, anybody have any research they want to do? And gradually these fields matured and they reversed it as they should. So you want to have interesting questions that you want the answers to, and a technology that can help you do a better job. That's the right order of things, in my opinion. And I'm going to talk about how that might happen with respect to using big data in legal interpretation. I sound like a negative person, but if you get to know me, you'll see that I can be quite pleasant once in a while. So here is the version of the United States federal bribery statute. It's actually one sentence that's 199 words long, and with all kinds of provisos stuck in the middle of it. And if you look at all the case law under the bribery statute, you can see what it is that's causing the problems. That is, what is it that's subject to litigation. And what you find is just about every word has been litigated. But what has not been litigated is the structure of the statute. So what we all are able to do quite easily is to determine the relationship among the various people and activities. That's beyond controversy. So we certainly know that this is punishing the person who offers or gives the bribe. It's not punishing the person who takes the bribe. And it's not punishing their next door neighbor. You can see what the relationships are quite easily. And that has to do with syntax and legal semantics. And if you were to study linguistics in the vein of what we call generative grammar, which is the field that Noam Chomsky developed a half century ago, you see that in linguistics we like to think that there is some kind of computational system in which these relationships just come out from the way you talk, and there's really not much of a problem with those. There are ambiguities that occur, but you don't really see them very often. What you really see instead is problems of word meaning, which is about how we conceptualize. So word meaning is very flexible. It's accordion-like in nature. And so when you hear a word, you can, there's prototypical instances of that word. There's ordinary senses of that word. And then there's some outlying meanings that it's hard to know whether you want to call something an X or you don't want to call it that. So all of the problem with legal interpretation is much more about word meaning and conceptualization than it is about language more generally. Now let's see if I can push this button and do. Now I have a problem because I skipped something. Let's see a page. Good. So the statute says you're a briber if you do any of these, if you do all of these things. And notice that some of them are in the alternative, such as give, offer, or promise. In old-fashioned logic, we call these Boolean operations because of the logician Boole, mathematician. And what that means is that all of these can be connected with only three things: and, or not. So you have a list of elements, and the only logical connectors among them are those three. And that's really a classical definition, and that's what it looks like. The problem is, who counts as a public official? What about anything of value? Does it have to be, what if you thought it was of value and it isn't? What if you thought it wasn't of value and it turns out that it is? If you didn't think it was of value, then maybe you corruptly give something of value because you didn't even know you were giving anything of value, and so on. So all of these issues as to the definitions of the words have been litigated to the hilt in the United States. I don't know if you're aware of this, but people sue each other in the United States. And this is the point I'm making, because rules are written in words, and word meaning is not very rule-like. Rules cannot be entirely rule-like. That's really what you see. That's the problem that we For those of you who are lawyers, you know this anyway. This is what you do for a living. But I'm trying to articulate in a way that relates to the learning of another field. So these are the kinds of problems you have. So in one of them, there was a cleaning service that was cleaning a public housing project. And they did a bad job. So one of the tenants tried to give some money to the private cleaning service so they would clean that area of the apartment complex. And the person was prosecuted for giving a bribe to a government official. That's not a government official, that's the janitor who works for this cleaning service. And he got convicted, and the courts upheld the conviction, saying that if you're actually performing the work of the government, even if the government outsourced that work, that's the equivalent of bribing a public official. And whether you like the result of that or not, it's not surprising that that kind of issue arises. I'm not crazy about that result. Well, I'm not the first one to think of this. A couple of weeks ago, Aristotle wrote this. And he was mostly right. There was no cognitive science to study back then, and for somebody in antiquity to have this level of insight into the human condition is just remarkable. So every law is laid down in general terms, while there are matters about which it is impossible to speak correctly in general terms. Where it's necessary to speak in general terms but impossible to do so correctly, the legislature lays down that which holds good for the majority of cases, being quite aware that it does not hold good for all. And in other writings, he said that's why you need judges, to make sure that we don't say that laws apply to situations that they weren't intended to apply to. The law, indeed, is nonetheless correctly laid down because of this defect, for the defect lies not in the law, nor in the lawgiver, but in the nature of the subject matter being necessarily involved in the very conditions of human action. Well, that's not quite right, the end of that. And if anybody has time to call up and tell them, I don't think we'll be insulted. What it really is about is that the way our minds apprehend the world are such that the flexibility of the concepts on the one hand, matched with the all or nothing nature of the legal system on the other, make it very, very difficult. So it's not that, so it really does have to do the problem isn't with the lawgiver, but the problem is in the relationship between those who have to both obey the law or judge the law, depending on whether you're in the judicial system or not, on the one hand, and the events of the world on the other. So the human mind is more involved than Aristotle thought, but that's the only thing that seems, thousands of years later to be wrong with this, and it's not much. Pretty good for somebody making it up, just in antiquity. It's really remarkable that there's so little wrong with that kind of statement about the legal system. So here, the leading unabridged dictionary of American English is Webster's Third. It was written in the 1960s first. It was very controversial because it was intended to be more descriptive than prescriptive. So there was an entry for the word ain't. And there's a book called Ain't, which is about the scandalous nature of that dictionary as received by the world of people who care about dictionaries, Dictionary Society of America and so on. And there was actually a conservative backlash against Webster's Third that led to the publication of the American Heritage Dictionary of the English language, which is a conservative answer to Webster's Third. So we have two major unabridged dictionaries of American English. And this is the definition of chair from Webster's Third. Well, I own a copy of it. Not that chair, I got that from the web, but I own the dictionary. So, and look at it. It says a usually movable seat that is designed to accommodate one person and typically has four legs and a back and often has arms. That's not a classical definition. It has one necessary condition which is a seat designed to accommodate one person. Everything else is about what makes a chair a prototypical chair. So it has the word usually, typically, and often. So what it's telling you is there are two kinds of knowledge that you need to know about chairs. One of them is what something has to be a chair. And that's not even a good definition, incidentally, because to me, a bar stool with no back is not a chair. I would never say, you know, I'm going to sit in that chair over there, I'm sitting on a bar stool. But putting aside the flaw of the definition, it's a mixture of descriptions of what makes a chair really seem like a classical chair. And these aren't classical chairs. But you would say they're chairs, but they don't have the squarish shape and so on. So what we have are two kinds of knowledge. One of them is about how well something fits into a mental model we have of what makes a chair a good example of a chair. And the other thing is what are the conditions for calling something a chair in the first place. And at times, psychologists and philosophers have combined those two, but now most think that those are two separate kinds of knowledge that we have. And to give you an example, if I asked you for a good example of a bird, and I said I have one, penguin. You said, that's a terrible example. Penguins aren't like any other birds. But then I would say, well, do you think they're any less a bird than a robin? You say, no, they're a real bird, but they're a lousy example of a bird. And that seems to be kind of how we think. That is, we draw category, we define categories partly on actual definitional features, but we also have an acute sense of what makes one example a prototypical example of that category, and other examples feeling like outliers. And there's psychological research that shows the further you stray from the prototype, the less consensus there is about membership in the category at all. And that can't be completely true because there's no doubt about penguins and birds. And there's no doubt about these being chairs, even though they don't have arms. But nonetheless, the experiments showed, at least in some contexts, what I just told you holds. You're probably thinking, is this guy ever going to talk about law? Well, one is determining the prototypical meaning of the term acceptable as legal argumentation. This is very important when the legal system tells you it is. So the decision about the relationship between prototypical meaning, which in law we call ordinary meaning on the one hand, and the law only holds when the law says that we care about the ordinary meaning. So if you have a rule saying that we defer to the ordinary meaning of terms in legislation on the assumption that that's what the legislature probably intended, then you should care about the ordinary meaning and you should want to get at it as well as you can. And that's what I'm going to talk about, how to get it to it as well as you can. And in the United States, I don't know how much, I can't speak to locally, but you can. The ordinary meaning rule is a default rule, and it's defeasible. That is, there's a preliminary assumption that when the legislature uses words that are not technical words, that they're expecting them to be understood in their ordinary sense. And that presumption is defeasible because you can have legislative history or context of some sort to tell you no, there want to be a broader or a narrower understanding of that word. But that's a presumption in American jurisprudence, and there's big debate among the judges about how defeasible it is. Because there are judges that are, we call the textualists, who say, well, once you have the ordinary meaning, you don't need to know anything. And you're better off not learning anything else. You're just going to get yourself into trouble. Because you're going to start putting your own values in the analysis. There are others who say the ordinary meaning is a defeasible principle, and it's good that we have it, but if you really know that the legislature wanted a broader meaning or a narrower meaning of what's ordinary, then we should obviously honor what the legislature wanted to accomplish. How much individual analysis you do of that depends on the philosophy of the judge. And the United States judiciary, I think, is more obsessed with these linguistic nuances in statutes than are most judiciaries. So how do you find out what the ordinary meaning is? Well, you can use your own intuitions, and because you know that a penguin is an unusual kind of bird, but it's a real bird, so you can just do that. And that really causes a little bit of a problem. Linguists are always using their intuitions about what makes something good English or good French or whatever language you're studying, or bad French or English. So in most languages that I know, 3, you can you invert the subject and the verb to ask a question. And that's true in the Romance languages, and it's true in German. But in English, you only do that sometimes, because often you have to insert the helping verb do. So in Spanish, you would say the equivalent of went John to the movies yesterday? But in English, you have to say, did John go to the movies yesterday? If you say, went John to the movies yesterday, you would show yourself not to be a native speaker of English, or a proficient speaker of English if it's not your first language. But in Spanish, German, French, you just invert the verbs without adding this helping verb. So, I know that because my intuitions tell me that went John to the movies last night is not a good sentence of English. I don't need anybody to tell me that, and you'd all agree with me. That's your intuitions about distributional facts about language use, though, are less reliable. So if you want to know of 3 senses of a particular word, which is the one used the most that you could call the ordinary sense? Who knows? And you don't know whether your experience with that word matches the population generally. So it would be good to have more information than just your ordinary intuitions. If what you really care about is interpreting the word in its ordinary sense as a legal matter. So there's a risk to just using one's own sense of what's ordinary. The second thing that judges do is they use these dictionaries. And in the United States Supreme Court, there are plenty of cases where the judges ridicule each other for using the wrong dictionary. You look this up in Webster's Third, that's ridiculous. You should have used Random House. Random House, that's even stupider than Webster's Third. You should use Black's Law Dictionary. Black's Law Dictionary, I wouldn't even let my law clerks look at Black's Law Dictionary. And the opinions look like that. Like kids in a school for delinquent adolescents throwing food at each other in the cafeteria. If I were speaking to members of the U.S. Supreme Court, I would not have used that metaphor. Now, or they can use linguistic corpora, which they're beginning to do to determine the distribution of usage and to draw inferences for ordinary meaning from big data. And then that's really why I'm here, to tell you a little bit about how that's been happening and where the limits of it might be. And Tammy and I have come up with 4 conditions for this kind of method to be used efficaciously. It's being developed at Brigham Young University in Utah. There is the large corpora of American English are housed. They were developed there by a linguist named Mark Davies. And it turns out that one of the former students there, a graduate student in linguistics at Brigham Young University, then went to law school at Brigham Young University. And one of his law professors was a guy named Thomas Lee. And Tom Lee then was appointed to the Supreme Court of Utah as a justice. And he hired this linguist, this former linguistics student, as his law clerk early on. The guy's name is Stephen Moritzen. And Stephen Moritzen taught Thomas Lee about corpus linguistics. And Lee said, this is wonderful, this is fascinating. So we have Justice Lee traveling around the United States now making speeches about corpus linguistics as a justice on the Supreme Court of Utah. Just if you want to know a little bit more about Thomas Lee, he was on Donald Trump's shortlist to be on the United States Supreme Court as a conservative justice that cares about language and is not going to be liberal. So, and that's not surprising with respect to obsessions with this corpus linguistics. So I'll talk a little bit about why we think there should be limitations. The first limitation that Tammy and I think we have to care about is what I've already spoken about, which is that it's up to the legal system to determine whether ordinary meaning should carry the day. And sometimes it shouldn't. And I'll give you a couple of examples later. So if the judges say, wait a minute, we have enough information to understand, as did Aristotle, that this law should not be applied in this situation, regardless of just looking it up in the dictionary or the corpus, then there's good reason not to. So just don't. The second condition is that you need to know what you mean by ordinary meaning. What does ordinary meaning mean? And that's not such an easy question because there are two approaches to it. One of them is ordinary meaning is the meaning that is most prevalent. That makes some sense. But there's another way of looking at it. That's looking at language as something out there and just count the usages. And a corpus is great for that. You have 600 million words of English in the Brigham Young corpus. And a particular word occurred 900 times with one meaning and 400 times with the other meaning. The 900 wins. The second way of looking at ordinary meaning, though, is not that way. Ordinary meaning could mean a window into the human mind such that people would be comfortable using the word that way. In which case there may be more than one ordinary meaning to a term. So if you take the word bank in English, we use it more to talk, at least in urban culture, to talk about financial institutions than we do to talk about the side of a river. Yet, there's nothing extraordinary about talking about the banks of a river. So it may be that there's more than one ordinary meaning of a word because we're comfortable using it more than one way. And if the corpus shows adequate representation of both meanings to indicate that people do use it both ways without it being terribly unusual, that's good enough. And linguists talk about those two different approaches to meaning as the external approach to meaning, which is that language is out there and you just want to see how much this way of it is used or that way. And the other way is internal. So they call it E-language for external or I-language for internal. And I-language is saying that language is really a matter of how the mind works, and you want to see whether the mind is comfortable using the word in one way or more than one way, and so on. So these two approaches to ordinary meaning, one of them is just adequate representation of the corpus, and the other one is whatever predominates, really make a difference. They make a difference in terms of one's philosophy of language. They make a difference in terms of legal outcomes. The third thing you need to do is to figure out what searches you're going to do. If you have 600 million words of English and the word carry is in the statute, you have to decide how broad you want that search to be, just as if you were doing legal searches using the legal database services like Westlaw and Lexis that we use so much. And I'll give you examples later where there are problems with that. And finally, getting back to this business of internal versus external, if something's missing from the corpus, so you're looking it up, you say, oh, I see this meaning but not that meaning. There are two reasons for it. One reason might be that we're really not comfortable using language that way. And that is the corpus search is doing just what it should do. Well, there are two possible ways of using this word, but people barely use it in sense number two. They only use it in sense number one, even though they both exist. But there's another thing that could happen. It might just be that people don't talk about certain things so much. So I did a search in the corpus of American English with 600 million words. First I went on the internet and I looked up rare birds of Malaysia. And Malaysia has beautiful birds. And I saw one called the blue pitta, P-I-T-T-A. And then I looked up blue pitta in the American corpus called COCA, Corpus of Contemporary American English. And I didn't find any instances of blue pitta in the American corpus. That doesn't mean that the blue pitta isn't an ordinary bird. It just means that Americans don't talk about blue pittas, except for me. So if that's the case, there's no real reason to be upset at its absence. So you have to decide if something's not in the corpus, whether that's a linguistic issue, in which case it means it's outside of ordinary usage, or it's just something nobody was talking about, in which case it may not be relevant that it's absent, depending on what you're going to do with the search that you've done. So this is what, now we're going to just finish by giving you examples of all these problems. Poor Eugene saw this one earlier. Right after 2001, 2002, there was a scandal in the United States about a company called Enron Corporation, which was an energy corporation in California. They were manipulating energy prices illegally. And the company closed down, and senior people were convicted of crimes. Some of them went to prison. While the Enron scandal was going on, they wanted to go after, they were about to subpoena, they meaning the federal government, subpoena the records involving Enron from Enron's accounting firm. I think it was Arthur Andersen. But before they could get the subpoena out, so Arthur Andersen would be obliged to produce the documents, Arthur Andersen destroyed all the documents. And they were convicted of obstruction of justice. The Supreme Court reversed that conviction for obstruction of justice, saying if Arthur Andersen had a former client that no longer exists and it wanted to throw out the documents and the government hadn't asked for them yet, it had every right to do that. So Congress then passes a big law involving all kinds of requirements of financial transparency called the Sarbanes-Oxley Act. And that law had this provision as part of it. Whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede or obstruct justice shall be punished. Now fast forward 10 years to a guy named Yates who's running a fishing boat off the coast of Florida. And he's catching grouper that are smaller than the legal minimum size to keep the fish. And they're in a crate. The police are about to board the boat. So he throws the fish overboard. And he's then prosecuted for violating the Sarbanes-Oxley Act because he destroyed a tangible object to evade an investigation of a criminal activity. And namely keeping fish that are too small. And he was convicted, and the conviction was upheld on appeal. This is Aristotle's problem. This is exactly what Aristotle was talking about. So the question is, should the statute apply to this situation? And a majority of the justices on the Supreme Court, in a 5-4 decision, divided, they said nasty things to each other, said no, it shouldn't apply to this situation. And the reason it shouldn't is because, as a matter of language, first of all, there's a canon of construction that says that you construe words of a statute as relating to the neighbor words, the neighboring words. It's not a justum generis. What's the other one that's nocitur associes? Do you use these Latin? Do you talk that way? We do talk that way. So my excellent Latin shows you why I was having trouble with the French before. So the question was, should you just look at the ordinary meaning of tangible object, which certainly includes dead fish? It's right, that's at the heart of the matter. It's a tangible object. Do you just look at that, or do you ask questions about the context of the enactment of the statute, including the linguistic context? And the court was divided 5-4, with the 5 saying, we're going to look up the context, and this has nothing to do with dead fish. This is about destroying a hard drive or something like that that has financial information on it. And the dissenting justice said, I thought we knew that we look at the ordinary meaning of the terms, but apparently I'm wrong. I must not know how to read, or you don't. It's nasty, back and forth. And so anyway, that's what happened in that case, and they decided a narrower reading than the ordinary meaning should prevail. Here's another one. In the 1960s, part of the civil rights legislation that was enacted, they enacted the Voting Rights Act, which prohibits discriminatory voting schemes in elections. And in Louisiana, state Supreme Court justices are elected, and the voting scheme for those elections appeared to be racially fixed, so that you would really never get a black Supreme Court justice in Louisiana. And so a lawsuit was brought, and the defense to the lawsuit was that the Voting Rights Act talks about the election of representatives, and a justice on the Supreme Court is not a representative. It's a member of the judiciary, but not a representative. So the question is, should the word representatives in the statute be limited to talking about legislators? And obviously, the ordinary meaning of representative in this context is a legislator. It's not a judge. If you talk about a judge as your representative, it sounds like you have a corrupt judge. It's just not how you talk. But the Supreme Court said the likelihood that the Congress was intending to create a safe harbor for racist election schemes in Louisiana, the heart of racism that led to the Voting Rights Act in the first place, is just absolutely an absurd thought, and we're going to take a broader than ordinary meaning of representative and have this law apply to the vote to the election of Supreme Court justices in Louisiana. Dissenting from the right, Justice Scalia, our late justice, who was flamboyantly, conservative and entertaining sometimes, said, the same thing. I thought we knew how to interpret statutes, but apparently I'm the only one who does. And same kind of nasty back and forth. And it was again a fight between looking at context, looking at the purpose of the law, on the one hand, what Europeans call the teleological approach, and looking at the structure of the law and so on, or just looking at the language and looking at the language as a proxy for all of this. And it's, and you see what happened here. Heavily divided, although the language people lost. Now here's another problem. Smith trades his unloaded machine gun for cocaine. And there's a statute that makes it a crime to use a gun in a drug trafficking crime. So the question is, did Smith use a gun when he traded it for cocaine? And 6-3, the Supreme Court said yes. And it's been ridiculed because nobody talks that way. But it's not that crazy for a couple of reasons, although I've written very critically about it. First, the purpose of that statute is to keep guns away from drug crimes. So if somebody says, I didn't use it as a weapon, I only wanted to put a machine gun in the hands of a drug trafficker, but I wasn't going to shoot him, that's not the most sympathetic defense. So if you care about what the statute was intended to accomplish, it's relevant there. Secondly, there's something funny linguistically here. If you say, is that an ordinary way to talk about using a gun? No, it's an unusual way to use a gun. No doubt about it. But once he did it, you say, gee, I can't believe it. This guy Smith used his machine gun to get some cocaine. He traded it. That doesn't sound so crazy. So it's not an unusual way to describe what he did once he did it, but it's a very unusual way to use a gun. And the Supreme Court, what with the purpose of the statute, and this time Justice Scalia dissented from the left, based on ordinary meaning and ordinary usage, and of course, in one sense, he was entirely right. In another sense, he wasn't. So there's confusion about what we mean by ordinary meaning. Now here's another problem. What search should you do? So far we have to decide that we care about ordinary meaning, which sometimes we do and sometimes we don't. And then we have to decide what we mean by ordinary meaning, and there's no consensus within the judiciary about that. And the third thing is what we're going to search anyway. So a police officer lied during a disciplinary hearing. These three cops pull over a motorist, and one of them beats the motorist up for no particular reason. And then they say, well, this guy was resisting arrest and he was violent, but he wasn't violent. And the reason we know that is somebody had a mobile phone and videoed the whole thing. So after the police testified falsely at their disciplinary hearings, they showed them the video. And the police were then prosecuted for obstructing justice. The reason there's a law that says that the use of information from this disciplinary hearing cannot be used against them later is because the law want to be able to compel police officers to testify at their own disciplinary hearings. But you can't make them do that if their forced testimony could result in criminal prosecution, because that would be unconstitutional. That would be making somebody be a witness against himself in a criminal proceeding. So they have this law insulating disciplinary hearing information from subsequent use in a prosecution. That's what the law's for. And most states have it, and they should have it. Then they can compel the testimony in a disciplinary hearing. So there's 7 justices on the Supreme Court of Michigan where this happened. And all of them said, we are really lucky. We just met Tom Lee from Utah. We're into this corpus linguistics business. We think it's great. So 4 of them say information, they're all using it. And 4 of them say information includes false information, so that you can't use it against them. And 3 of them say, no, it doesn't, but they lost. And the reason that there's this division is because the 4 justices in the majority looked up the word information in COCA, and there were hundreds of uses of it, and from Brigham Young. And of those uses, they saw false information, inaccurate information, misinformation, bad information, and so on. It's used all the time for different purposes. The dissenting 3 justices said that the statute just uses the bold word information. And if you take away all these modifiers and you just talk about information, you don't really usually talk about it when you're talking about something that you know is factually wrong. So if I say I'm going to give you some information, you would trust that I'm giving you, at least I believe that what I'm telling you is true, and that you're getting information that I believe is true, even if I'm wrong about it. So there's a fight there about what search you should do. Finally, we have a case, the same law that makes it a crime to use a gun in a drug trafficking crime makes it a crime to carry a gun in a drug trafficking crime. So when the guy has drugs in the glove compartment and a gun in the trunk as he drives to the drug deal, does that mean that he carried a gun to the drug deal? Or does it mean that he just transported it, but carrying a gun really means having it on you in some way? Justice Breyer, who's sort of a little bit on the liberal side of the court, writes, no, that carrying it on your person is just a special use of carrying. It's like packing heat. It's an outlying use. Carrying really means putting it in a vehicle. And he says, see, carry and car have the same etymological roots. And they look up the word carry in literature, and they see from Oliver Goldsmith and from Daniel Defoe, they're always carrying things on animals and so on. So, and that's the way, that kind of, the Bible used carry in that manner. So if it's good enough for, for the Lord, it's good enough for us, and so on. Then he did a corpus search. And he said 1/3 of the instances of articles, he just looked up news articles in Westlaw News Library. And 1/3 of the instances of words carrying, weapon, and vehicle near each other have you carrying the weapons in the vehicle. And Justice Ginsburg dissents from the left and says, What happened to the other two-thirds of the cases? What are you talking about? Then this guy, Stephen Moritzen, he's the person from Brigham Young who taught Thomas Lee corpus linguistics. Stephen Moritzen does this search in an article where he leaves out the word vehicle. He says if it's just carrying a weapon, or does it usually used to mean carrying a weapon in the vehicle or carrying it in your pocket? And he says, well, 1/3 of the time, it's carrying it in your pocket. And 2/3 of the time, you can't tell because you don't know where they're carrying it. The news article just mentions that they're carrying a gun. And I think that that means that the rule of lenity, the rule that criminal law should be, that uncertainty in criminal law should be resolved in favor of the accused should have applied in that situation. Because 1/3 of the time the guy would be out, 2/3 of the time you can't tell. It doesn't look like that case came out the right way, in my opinion. Now, what happens when there's something missing from the corpus? That is, you want to know whether there's two different senses of the word, and one's missing and one isn't. Well, then you have the blue picture problem. You need to decide that the absence of the word is because people don't like using the word that way. But the blue pizza problem is illustrated here. So if you see this puzzle for young children, and you see that the circle is red, young kids can conclude that a circle is the word for a red shape. But it isn't, it's the word for a circle. Or you can conclude that it's the word for a circle, but all circles are red. There are a lot of things you can conclude here. There's a paucity of data. You could straighten it out soon when you see, when there's more circles and you see that they don't have to be red. But here, this is your database. This is what you're seeing. The absence of a green circle can be misconstrued. And so now there's an issue with respect to what makes ordinary meaning ordinary. And this is very important. It could be that it's whatever comes up the most, but it's also possible that the most ordinary instance of something is the one that has the essential features most prominent. And the example I like to use is the giraffe. Because the giraffe is the prototypical tall animal. But that's not because you see more giraffes than you see camels. You probably see more camels than giraffes, and you probably don't even know which one you see more. But you'll all think that the giraffe is the prototypical tall animal anyway. That's because there's nothing about a giraffe except that they're tall. They don't have anything else going for them. Whereas camels have those humps. So the essence of a giraffe is its tallness. And so if the most exaggerated essence of the giraffe is what the essence of being a tall animal is, you match it that way. And in the area of cognitive science, there's debate between whether the prototype is a function of central tendency, that is what you see or hear the most, or it's a matter of exaggerated essential features, with the latter coming in strongly, right now. It's a very excellent scientific research in the United States. So there you have the problem, and the example I like to use is there's a very famous case called Church of the Holy Trinity versus United States from 1892. A church in New York paid to bring over a minister from London. And there was a law at the time saying that it's a federal crime to pay for the transportation of somebody to come into the United States to perform labor of any kind. So they prosecuted the church for having violated that law. And when it got to the Supreme Court said, that's not what you think about when you're thinking about labor. When you think about labor, you're thinking about manual labor. You're not thinking about this kind of stuff. But in addition to that, they said when you use the word labor, it feels awkward to think that you're talking about the clergy. And you can say, that Father so-and-so, really works hard. But it's very hard to say Father so-and-so is really performing, hard labor. That sounds like Father so-and-so is in prison. And so you just don't use it comfortably that way. And it's not because you can't use it. You just don't because it's an awkward outlier use as opposed to a prototypical use. And it's that kind of thing that we're seeing with this puzzle or with the blue pizza problem. And that problem is ignored sometimes in the literature. I think I'm not going to give you this example. It's a mistake that Tammy Gales and I made. I'd rather show you somebody else's mistake. So here's the Second Amendment to the Constitution says something like a well-armed militia being necessary for the preservation of freedom, the right to keep and bear arms shall not be abridged. I got the language of the first part wrong, but not terribly wrong. So the question is, what is the relationship between those two clauses? And the Supreme Court of the United States decided about a dozen years ago that the first clause is just telling you why you have a right to keep and bear arms, but it doesn't mean that the right is limited to military service. And there was debate about that with historical arguments and so on that were really quite badly done, incidentally. Some researchers from the University of Chicago have been using Google Books to look at 18th century books to see how that expression was actually used in the 18th century. And they're finding that you find it almost exclusively in military context. So they talk about bearing arms when they're talking about people going into the military. But you don't find people saying, you know, honey, what are you doing today? I'm going duck hunting, I'm about to bear arms. Nobody would talk that way. But they only looked at the military examples, that is the Chicago researchers. And I didn't tell you this. I made the same mistake with Tammy in an earlier paper, but it just took a long time to go through. I think I'll spare you that. You just trust me that I was wrong. and so was Tammy, by the way. And but this is a simpler example. That's why I'm using it, not to exonerate myself. But I made the same mistake as what I'm saying with another case. To button down this argument so you don't have the blue pizza problem or the children's puzzle problem, they should have shown that in the 18th century there's plenty of talk about hunting. And when they talk about taking their guns to the hunting trip, they don't use that expression. And in cognitive work, we call that double dissociation in brain science, really. Because there's two kinds of aphasia, for example. One of them prevents you from understanding well, and the other prevents you from speaking well. And those different aphasias engage different lesions in different parts of the brain. And the scientists, the famous Russian neurologist Luria, the neurologist like Luria said you want to double dissociate. That is, you want to show that not only is Broca's aphasia a function of having a lesion in Broca's area, but that when you have Broca's aphasia, you don't have Wernicke's aphasia. When you have Wernicke's aphasia, you don't have Broca's aphasia. So lesions are associated with the particular diseases, but they don't cross. You have one or you have the other, and that's it. And that's really what you want to show here. If they had the hunting examples, which I hope they do in the future, then they'd be able to finish their argument. So just to conclude now completely, instead of just promising to conclude, the looming question is whether corpus analysis of legal authority should focus on internal workings of the mind, in which case we should say there could be multiple ordinary meanings because we're comfortable using a word in multiple ways, or e-language, meaning there's an external thing called language out there, the same way that there's something called trees out there, and you just count them. So are we caring about linguistic knowledge? Are we caring about the corpus as reflecting our knowledge in our minds? Or are we caring about the corpus reflecting our behavior? And there are good reasons for caring about behavior, but I don't think this is one of them. I think this kind of analysis should be about the mind. So I think it's, and because of that, it's harder to use, and that's why we have all of these conditions. But I think there are always going to be cases in which the judge has to decide whether a word's being understood in an ordinary sense, when it comes to an interpretive problem that you have before a court. And there are times where this kind of methodology, I think, can do better than anything else. You just have to rein it in an appropriate way. So that's it. Thank you so much.
Perhaps there are some questions or observations, comments. I think I'm going to invite Larry to sit.
Thank you. Please.
Courts in the United Kingdom, when they're considering statutory interpretation, if they reach a dead end, they sometimes look at Hansard, which is the notes of the Parliament.
Right.
So you didn't refer to that at all. Is your need for this analysis of the language because it's not as available in the US, or is it because your statutes are, for example, are they older, or are they in the records and you need this, or is it to complement that?
No, I just didn't talk about it, but it's an important issue there. So Hansard includes the oral debates, right?
Yeah.
See, in the States, there's a hierarchy of reliability of legislative history, with the debates being towards the bottom, unless we're talking about the best literature on that talks about situations where somebody, if there's a situation where somebody supporting a bill is trying to convince an opponent that they're wrong about a particular objection and says we would never want X to happen, and then the opponent ends up voting for the bill, there's kind of evidence that that bill was enacted with X not happening. That shouldn't be part of it. But the debate in the United States even goes to whether you should look at any legislative history. It's a bit more radical than in the UK. So the most reliable legislative history in the United States are the committee reports of the Senate and the House of Representatives, because they are explaining in detail the plans of those houses as to how the law is going to work in real life. They're not drafted by the legislature. There are philosophical objections to using it because they weren't enacted and so on, but they really can teach you a lot. So the more radical of what they call the textualists, so you shouldn't be looking at anything other than the language and certain canons of construction and the history of judicial opinions. You should always care more about what the judges have said than what the legislators have said. So the equivalent of the Hansard debate in the United States is really about stray remarks by particular legislators in the course of the enactment process. And if it's just a stray remark, they're not really given very much attention. If it's a matter of those who have proposed the bill trying to convince others that they don't have to worry about particular problems because they're just imagined, and they get those votes, then that's considered reliable in that sense. Most judges will look at legislative history. They'll look at these committee reports, sponsor statements. So you have a different process before that because we don't have a parliamentary government. So you actually have the government, you have the ministers proposing the bill, you have white papers and so on. We don't have anything like that. We don't have, whatever was proposed might have been paid for by lobbyists and, the ideology of the bills are much murkier in the United States. But if there's reliance on white papers and things like that, that's where the debate is even located there in the United States. And the Hansard debate is not that different in the States than it is here, except there weren't, it doesn't have the history with, what's the name of the famous case, Pepper versus Hart, yeah. So we don't have a Pepper and Hart.
You mentioned before that when they're drawing from these bodies of information, these corpora, one of the examples you gave was news articles.
Right.
So is that kind of, do they exclusively draw from news articles, or are they drawing from a kind of range range of material that's related to decided cases where that information might have come up before, or, and what's the impact of that?
Right. I'm going to restate your question slightly more broadly and then respond to it that way, because when you're going to use a corpus, you got to use a relevant corpus. So if you used a corpus of children's literature, it would be silly. How do you know what's a relevant corpus? Well, the big corpora of American English developed at Brigham Young draw from 5 different genres equally. And one of them is news and current events. One of them is fiction. There's actually spoken language there. So there are 5 of them. They have 120 million words of each of them. And if it turns out that if you look at Google News, you're only going to get what reporters have been saying about particular kinds of events, and it could be quite limited. On the other hand, newspapers, the media in the United States, that is the sophisticated media, are directed towards high school students, people who can read at a high school level. So the New York Times, which is considered elitist and snooty, actually is written at a high school level, whereas other newspapers are written below a high school level. So the idea of just using news articles, it's very selective. And the thing the debates that have not occurred yet within this corpus world is if you have a corpus that has 5 different genres, should you be careful in selecting which of those 5 genres to search? Because you can tell the corpus, don't bother with these 2 genres. And the work has not gotten that far yet. So what you really need is controls. You need to take actual cases that were decided, do these kinds of searches in different ways, and see whether it ever makes any difference how you do it. Because it may be with 120 million words for each of them, it really makes no difference. But it may make a difference. There is no such empirical work that's been done so far, so there's a level of unsophistication at that level.
Really interesting, really fascinating, a little bit worrying to see how judgments are flipped on such a narrow margin and no one right answer as to which way it should be interpreted. But I just wonder, just that comment that you made about, you wouldn't look through children's literature because that would be ridiculous, and yet we expect children from the age of 10, for example, to be criminally accountable. And so their understanding of ordinary language as used in statutes is something that we do potentially need to consider. So I just wonder, is there a reverse engineering process that can happen? So rather than having the judges figure out what this analytical framework of language should be, do we have drafters who have that insight? And would that be helpful? Could it work?
Well, I mean, to get back to the question you were asking before, there's technical language sometimes. So we always want, if there's a word that was intended to be used in a technical sense, we want it used in a technical sense. But generally, it's all intuitive. So, and the drafters, there's a combination, there's a little bit of chaos in the enactment process in the United States Congress, for example. Some of the state legislators are a little more organized than what they do. So there's professional drafting staff in the Congress, and they write the laws, and the staffs of the congressmen write the laws. But then there's a lot of changes made on the floor. So if you look at the recent tax bill passed by the United States Senate, the final copy that was passed has all kinds of handwriting in the margins. Somebody wrote that stuff in. I don't even know whose handwriting it is. So there's nothing unreliable about that as a matter of what was actually enacted. If that's what they enacted, that's what they enacted. But there's something funny about thinking that there's an actual drafting process. And there are some legal scholars in the United States, particularly at Yale, Abby Gluck and Bill Eskridge, and there's a woman named Victoria Nurse at Georgetown, who have been calling themselves legislative realists. And they've been trying to match the interpretive process with what we know about the enactment process. And that's especially interesting, say, when it comes to the Obamacare litigation that occurred. Because the problem with the Obamacare statute, one of them had to do with two separate congressional committees drafting adjacent parts of the law and then having them put together where they use different vocabulary in different ways. And when you understand that that's what happened, you will become more sympathetic to there being some kind of a structural approach rather than just looking at the language and saying these people didn't know what they were doing. They did know what they were doing. You just had two groups of people doing it, and it was so long that they failed to reconcile it in a few areas. So there is effort to try to figure out what's going on in those situations. But I wouldn't say these kinds of language nuances that I'm talking about are really something that's appreciated that well in the drafting process. It is very unusual, incidentally, for there to be this corpus linguistics business, this big data, which is being driven by the judges wanting to know more from the linguists, is pretty much unique in American language and law history. So most of it are the linguists trying to tell the legal system that you think you know about language, and you don't. You have to rely on us, and you should pay us for it. So it's a little self-serving. But here we have a situation where the judges are saying, we'd like to know more about linguistics and see if we can do a better job of what we're trying to accomplish anyway. As you can see, I have some mixed feelings about what they're trying to accomplish, but I certainly don't have mixed feelings about they're doing it well when they do it. So I think this is really a pretty interesting step. And the University of Chicago and Brigham Young are the two educational institutions that are most involved in this.
Larry, do you see any crossover in the kind of, so you mentioned the splits on the Supreme Court of various jurisdictions, state and federal, at various points. So I suppose the kind of theoretical split that we would be familiar with on the Supreme Court in particular would be between the originalists and the kind of hermeneutic branch of the, looking at the context, I suppose. Is there a kind of, does that map onto the people who are keen on using
Yes,
linguistics?
It's the right-wingers who are most excited about it.
Why?
Because, first of all, they like the idea of uniform procedures in statutory interpretation. So in a book that Scalia wrote in the late 90s called A Matter of Interpretation, he was praising the European tradition of legal science and science of interpretation and so on. And he was entirely wrong about what he attributed to the civil law tradition. So he was attributing to the civil law tradition the absence of concern about legislative history and Hansard and so on. It's absolutely not true. The European tradition embraces looking at the history of why a law was passed and how it was passed. It might not go for the oral debates, but it certainly cares about the historical perspective, and it cares about the structure, and it cares about the language, and the history, the grammar, the structure, and the teleology, the purpose. That's the principal thing. So the goal was to do that, but only to look at the language and thinking that that's the only thing that's scientific. And what makes it scientific? You look it up in the dictionary. So it's a motivation that's understandable, but it really wasn't being carried out in a way that's terribly worthy of respect. So that's one thing. On the other hand, I don't know how many judges are really doing this, but I think that the people interested in this corpus business understand that they're dealing with computer scientists and big data and so on. And I'm not saying that everybody can't, that the whole judiciary can't wait to read what Tammy and I are writing, but the people most involved in this are reading the literature and trying to do it as well as they can. I think what they're trying to do is is too mechanical, and you should really back up and think about why a law was passed and how it was passed and so on. And as I've been, I've said the legal system should decide whether you should be doing this. It shouldn't just be automatic, automatic pilot. So I think that there's a little bit more chance for interaction now because there are people with different perspectives wanting to be done well. But I can't, I'm usually wrong when I predict things, so let's see what happens.
I want to greedily ask a second thing, but I suppose the difference then, if you're considering the literal interpretation, you take your example of carrying a gun. So we might, in this jurisdiction, go more of the spirit of that legislation.
Right.
So you might go back to Hansard, and I should say, if you're going back to Hansard, you're normally difficulty. So if you go back to Hansard and you say, well, what's the spirit there? Well, that's obviously an aggravating feature of the offence to carry a gun, and it couldn't possibly make sense that to carry a gun in the glove box is as bad as carrying a gun in your person or in your hand. So therefore, to analyse the carrying of the weapon is missing the point of what that particular element of legislation is supposed to protect.
I think that's entirely right. So when you start trying to come up with the meanings of particular words, and you reduce the inquiry into the specific context of the enactment, you lose exactly what you said you lose. And incidentally, that is the goal of the textualist program, is to come up with a few things that you know you're going to look at the expense of individual inquiry, on the theory that judges are going to insert their own personal values into what goes into that inquiry. And therefore, if you specify in advance a limited set of evidence, you're going to have a less value-laden judiciary. But first of all, I don't think it's true. And secondly, even if it is true, if you have less personal values of judges infiltrating at the expense of intelligent inquiry into what really happened, that, that's not necessarily a good trade-off anyway. You're right. I agree with exactly what you said.
Is there a particular reason why you see this being limited to interpretation of legislation? Is it common law?
Well, it actually isn't. So there's a conference at Brigham Young University in March, which I'm going to be speaking at, and the conference is going to take place near the university at a ski resort, just to let you know the seriousness of the event. And the theme of that conference is using this kind of method in legislative contexts, constitutional contexts, and contracts, interpreting contracts, where the interpretive issues are relatively similar, but the legal principles are different. And are there differences in the efficacy of using them that way? I've not written about contracts with respect to this, but I have written about the Constitution. They're developing a new corpus of, they have these initials. So COCA is Corpus of Contemporary American English. COHA is Historical American English. And now there's a new one being developed that's going to be released soon, COFIA, which is Founding Era American English, which is a multi-million word corpus of 18th century English, obviously mostly from England. And there was a debate in some literature, and I participated in that, saying, I'm not going to tell anybody they shouldn't do something, shouldn't produce learning, why should I say that? But I really had my doubts about its efficacy because there is no single received theory of constitutional interpretation. And it's what I said at the beginning of my talk, that if what you're going to do is say, well, we have this new toy you can play with, find out what you can do with it, that's not as good as saying, we know the questions that should be asked as a matter of political science and legal theory, jurisprudence, and here's how we can answer them best. So I don't really know as a matter of constitutional law whether you want to care about the way a word was used most in the 18th century. Because the Constitution, it's a relatively short document, and it may well be, for example, there are theories that say that powers given to the government should be construed narrowly, but rights given to the people should be construed broadly, which is not the same as saying that everything should be understood in terms of its most prevalent usage at the time, looking up things in Google books or whatever they're going to use. So I have some mixed feelings about that. And then also the originalist examples are never terribly interesting. So one of the leading originalist scholars, who's somebody I respect quite a bit, partly because his name is almost exactly the same as mine, Lawrence Solan, S-O-L-U-N. And he's very, very good, he's very smart. And the examples he always gives of wanting to care about the original meaning of the words is that in the 18th century, if you look at the Constitution, there's a provision that talks about the president fighting domestic violence. But that wasn't about spousal abuse. That was about armed insurrection. So he says you don't want to take the contemporary meaning and then say that's what the Constitution says. Of course you don't. And then another example is you have a right to a jury trial in a civil case if the civil case has a value of more than $20. But there can't have been $20 because the Constitution was written before there was a bank that had authority to issue money. So what could they be talking about? They were talking about Spanish silver dollars. That's what you meant in everyday speech when you talked about a dollar in the 18th century, late 18th century in the colonies. So if that's what, so he's right about all of that. But that has nothing to do with how much you should talk about freedom of the press as and the internet or something like that, where you have really hard questions about how words that had particular extensions back then might be understood now. And the big debate on that is about capital punishment, because the Constitution prohibits cruel and unusual punishments. And back in the 18th century, execution was not unusual at all. And it was, so one body of originalists say that cruel and unusual punishments means punishments that are harsher than social norms would permit. And that hasn't really changed very much over 200 years. So if that's the case, the list of what goes into that box might change, but the concept hasn't changed at all. Others say, no, you get a list of what you can do back in the 18th century, you can do that forever. So we're not sure what we mean by original meaning. And there's a very difficult example. We're not sure what we mean, and we don't even have a theory of what to do with any of this stuff. So all in all, I have serious doubts about using it in constitutional context. As far as contracts are concerned, I haven't looked at it yet, but I will. I'll do it by March, when I show up with this.
If there are no other questions, I'm going to friend something about drafting.
Well, I was about to say something I thought perhaps better not. What drafting in the UK and where Commonwealth countries is highly professionalised, and I know that the US, the Senate has been looking at whether they could possibly create a drafting profession. I know that there are only a few drafters in Congress who must do a very big job in trying to fix up the handwritten amendments, etc. So our drafting profession within the UK tend to be a highly qualified lawyer and then spend roughly 5 to 7 years perhaps training in that profession within a profession, so it's very different. So I'm interested that there are quite a lot of legal academics looking at this at the moment and trying to organise conferences. So perhaps the linguists and the academics could come together at one of those.
Well, it would be good if they did. And there's a guy who used to be drafting in Parliament named Greenberg, who wrote a little book about this that
We know him well.
Oh, do you?
Oh yes, we've worked with Daniel for many years.
I can't remember his first name.
Daniel,
yeah. He's a real character.
certainly is.
So I heard him give a talk once. The drafters in Congress and the Office of Legislative Counsel are good. They just don't always get to do too much.
Yeah.
Because, somebody's going to come in with a lobbyist, and there's going to be some, don't be repetitive. But they want to be repetitive. They want to make sure that the judges don't do anything that they don't want done 20 years from now. So you know, it's a difficult situation. And there are more omnibus bills passed in the U.S. right now, so they're not limited to one topic. They're, you know, let's make sure that we can, you know, that we can put issues of family planning into a bill that has to do with the preservation of national parks or something like that. So, you know, there's general political chaos that's occurring there with the professional staff trying to work around it. The states vary in how professional their directors are, but, you know, they have a staff. It's such an important point, and thank you for raising it.
Okay, if there's nothing further, I think we'll just offer again our thanks to Professor Larry Solan for a wonderful talk.
Thank you. Thank you very
much. This is also the occasion of the launching officially of our legal innovation website, legalinnovation.ai. I'm going to invite us for a couple of moments, the Director of the Legal Innovation Center, Dr. Kat Denver, to introduce that to us.
So these things which you run with CAS, because with CAS, it means that we're doing everything right. We launched the website last week, and it's been a combination of a number of months of effort to bring together a lot of content that we hope will be useful for students and practitioners of law. And it's the interface of law and technology, so for those who are new to technology and are trying to get to grips with various aspects of the domain and want to know how it applies in law, then it is intended to be a useful resource for you. It's also regularly updated with new information and goings on in the field. So if you haven't seen it already, I would encourage you to check it out. There's a members section. You can engage in discussion and dialogue with different people and also students as well who will be using that members section. So it's an ongoing project for us. We hope that you find it useful, and we encourage you to share news of it with your colleagues and people who find it useful.
Spread the word. Okay, thank you all very much.